held the United States of America's objection on the basis that Mexico had failed to identify and positively establish the nationality of one of the individuals in respect of whom it was demanding diplomatic protection. And lest it be said by India that Pakistan has somehow represented in a clear and unequivocal manner to India that it's not going to bother with evidence of nationality, that's simply not the case. There's no proposition of law advanced before this court with reference to any authority, the Temple of Bihar case, for example, to suggest that there is the doctrine of estoppel at large. There's nothing. The memorial and the reply of India are shamelessly devoid of substantive legal content. If India wants to argue estoppel, it's too late, but I'll make the argument for them, shall I? There is no clear and unequivocal representation made directly to India with the intention or effect that India detrimentally relies upon it, such as to constitute a waiver of the requirement for India to establish the Indian nationality of Commander Jadhav. State practice. The proposition I advanced, the proposition that none of the 177 states party to the Vienna Convention on Consular Relations disagrees with, because if they did, the others, because there are two here, they had ample opportunity, pursuant to the invitation of this court, to present themselves and take issue with the proposition that I seek to advance. But they don't, because this is an issue which states have refrained from becoming visible upon and adopted a position that I described as being one of studied ambiguity. With the consequence that it cannot be said that there is a general practice accepted as law, opinio juris, by states to provide consular access in cases where espionage was reasonably suspected, such as to evidence that any such practice was undertaken with a sense of legal right or obligation, which I respectfully observe is the essential requirement for a customary international law principle to have crystallized and to be evident. The ILC draft conclusion 9 with the rapporteur, Sir Michael Wood, provides us with ample understanding in this regard. And it's the state practice position as at 1963 that we're concerned with. And we know, I wasn't alive at that juncture, but we know that at this point in time, the world was troubled, sadly, as it seems to be now. All the more reason for the rule of law to be upheld, because those who were participating in this exercise to ensure that a convention could be adopted were describing the task in 1963 as thankless, because distrust and suspicion reigned everywhere, and almost all states had recourse to emergency laws and regulations. Two pivotal figures in international law, certainly for somebody like myself, I can't speak for India, and I daren't try to speak for India in its present incarnation. Sir Gerald Fitzmaurice, former UK Foreign and Commonwealth Legal Officer Advisor and then a judge of this court, had observed that national security would be the only reason with sufficient weight to justify restricting communications between foreign nationals and their consular officials. Grigory Tunkin, then head of the legal department of the USSR Foreign Ministry, in the negotiation process, as can be seen from the travaux, had made it absolutely clear that the USSR took the view that in case of espionage, and as an exception, there was no obligation to provide consular access which would otherwise be available. This was with reference to the language of without delay, subsequently undue delay. And he was calling for that language to be deleted, with emphasis being placed upon this particular issue. And what was the response of the chairman? A statement of general principle could not possibly cover all conceivable cases. If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. Now, India reads this as it reads anything in the English language in a somewhat topsy-turvy manner, but what does it mean? 3 propositions. The USSR, in plain and simple language, is making it clear at this juncture, espionage was a special case outside the general approach to questions of consular access. And second, the chairman agreed by stating that the general principle could not cover all conceivable cases, far from India's exhaustive rubric. There's a lot of flowery language in India's pleadings, but there's not much by way of substance. And further, the only way to read the chairman's comments is as follows. Any attempt to open up the espionage exception so as to include express language would throw the entire process of formulating the draft convention into disarray. How else do we read this? If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. He's not saying, don't be silly, there is no such an exception. He's saying, let's not touch that, shall we? Because if we do, we're not going to get anywhere. Of course, that's how I read it from my understanding of English, but if somebody else has got an understanding of English which is intelligible, logical, then I welcome them to explain otherwise. And perhaps, to some extent, this is why the preamble of the Vienna Convention on Consular Relations states as follows, affirming that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present convention. And that's consistent with Grigory Tunkin's observation. That's also consistent with the way in which their major powers were behaving at this material point in time. Now, of course, it's very rare for espionage cases to appear on the public radar, and this is the first time ever the Vienna Convention on Consular Relations is being considered in the context of espionage. 4 examples we have given, the counter-memorial and the rejoinder provide authoritative references. We're not talking about references from newspapers in some provincial town somewhere in the middle of nowhere. We're talking about US State Department official documents. We're talking about texts produced by authorities on this area. Mikhail Gorin, USSR national, 1938, despite a bilateral treaty on consular access of 1933 between the USSR and USA, he was only allowed access in the presence of a US naval intelligence officer, Colonel Abel. Many people will recognize him from the Hollywood treatment, Bridge of Spies, a USSR national, 1957, no consular access sought or provided, convicted of espionage activities. Gary Powers, USA national, 1960, no consular access, convicted by the USSR of espionage. 2 and 3 were swapped in Berlin. Mark Kaminsky, USA national, 1960, no consular access, convicted by the USSR of espionage. That state practice, such as one's likely to see in an area as shrouded in secrecy, as subject to subterfuge as this. But what have academics who have reviewed this got to say about it? Professor Lee, the leading authority on consular law on practice in 1961, 2 years before the negotiation was taking place, a frequent exception to the consular right to protect nationals and visit them in prison is in the case of spies. Clear. Even better, Bishwanath Sen, 1965, 2 years after the convention was adopted. India's honorary legal advisor, 1954 to 1964, 10 years. In his textbook, A Diplomat's Handbook of International Law and Practice, no less, says as follows: a frequent exception to the consular rights to protect nationals and visit them in prison is the case of persons who are held on charge of espionage, as evidenced by the practice of states. Of course, customary international law being customary international law, being based upon state practice and an understanding as to obligation, states are free to modify their own practice. India put before the court 2 examples of state practice yesterday, recent state practice, China and the detention of Canadian nationals, but there is an express agreement, detailed agreement between China and Canada on consular access, and Russia also. But we could give the court many other examples, but we haven't littered this court with examples of what's happened subsequently, because what matters is what the understanding was in 1963 so far as customary international law is concerned. That's what matters.